Good morning and welcome to Briefly Legal. My name is Starla Leverett, General Counsel for the Alabama Real Estate Commission. Today we are discussing the implementation of the new legislation regarding teams. This portion of the law will become effective October 1st, 2025. I do want this to be as interactive as possible, as always, so if you have a question, please raise your hand and I'll ask you to unmute your mic. So just a brief legislative overview. Act 2025-380 was enacted and signed by the governor in May of 2025 and includes newly added language regarding the definition and operation of teams. This is significant because when this goes into the law in October 2025, when it becomes effective, it's going to be the first time that the word teams has been mentioned in Alabama license law. This legislation formalizes how teams must operate in Alabama, defining what constitutes a team, regulating the branding and advertising of teams, clarifying broker and licensee obligations, and spurring rule revisions for the Alabama Real Estate Commission to enforce these requirements. So let's start first with the foundation, the definition of a team. Team is defined as two or more licensees within the same company who work together to provide services for which a license is required and who hold themselves out to the public as a distinct group within the company. A licensee who acts as a member of a team or holds himself or herself out to be a member of a team shall be subject to this section, and the section is 342739. That section sets forth that the leader of any team shall be designated as a team leader with the qualifying broker. The qualifying broker cannot delegate to the team leader the responsibilities and duties of the qualifying broker. So what this simply means is, although they're the team leader, you're not absolving the responsibilities that the qualifying broker holds. The qualifying broker is still responsible for the supervision of the licensee, and just like they would be for the team. So that does not absolve the qualifying broker of any of that responsibility, just because there's a team leader in place. The team leader shall maintain a list of the members of the team and provide this list to the qualifying broker. This portion of the section is what actually drove this legislation. We at the commission, when teams started forming and becoming more popular through Alabama, we did not know who was on which team. So let's say a complaint came in, about the ABC team. We didn't know who were the members of the ABC team. And sometimes the complainant, the consumer, only knew it as the ABC team. So we didn't know really how to get in touch with them, who to call, who the qualifying broker was, any of that information. So that's what actually spurred this, is that we needed to kind of put some guardrails on this and understand who was part of that team. So now, once the team is formed, that list must be provided to the qualifying broker. So the ABC team members, the list is given to the qualifying broker. As people move off and on the team, that obviously the list should be updated. It's very important to remember that that now will become part of the audit process with the commission. So if the brokerage is audited, one of the things we will look at is to make sure you have, as a qualifying broker, the list of all the teams in your brokerage. Also, if we get a complaint in or we just had a concern and we need to call to say, hey, we've got this complaint about ABC brokerage, we do expect starting October 1st, 2025, that when we call the qualifying broker, they will be able to immediately tell us who is on that team. Any questions about that? And one final part of that section is that no person shall be a member on more than one team. All right, the next part of this section is dealing with the advertising and naming rules. At a minimum, any licensee who advertises as being part of a team shall do the following. And that's shall, so that means you must. Include the name of at least one of the team members in the advertisement. Include the name of the company with whom the licensee or the team is licensed in the advertisement. Include the term group or team in the team name. So we have to have one of the licensees' name has to be in the advertisement. Of course, the brokerage has to be in the advertisement. And then the word team or group must be part of that team name. And you must also receive written authorization from the broker of the licensee to include the team name in the advertisement. Further, this statute sets forth that the commission can adopt rules addressing what words may or may not be used in a team name and how teams may advertise in the market. And we've already taken steps to do that. We have a rule pending right now that should be effective in February of 2026, that sets forth that what I just previously stated is already statutory. The team's name must either include the word team or group. Furthermore, the team's name must not use terms that could lead the public to believe that that team is a real estate company rather than a distinct group within the company. Such words that are prohibited from being used in a team name are not limited to, but specifically corporation, limited liability company, partnership, business, enterprise, and company. This is there because this could fall into the misleading category of advertising, because if you had put something, like the Starla Leverett brokerage is my team name, that can be very misleading to a consumer to say, oh, well, that's the brokerage and not just a team within the brokerage. So just make sure that that right now, as of October 1st, the team name must have team or group. And then as of February of 2026, those words are specifically prohibited. But please keep in mind that it could still be considered misleading under our regular advertising violation to put, the word brokerage in the team name at this time. And of course, as always, on any advertising material, just remember that we have the rule now that defines the word prominently. And this applies obviously to team advertising as well. So if your team name is in 14 font, the brokerage name must be, or the qualifying broker's name must be in 14 font or larger. The brokerage name has to be same size or larger than a licensee name or a team name, and that is currently in rule. And so we have to remember that we want to do that as well. Okay, any questions about that? Okay, so the takeaway from that portion is that always have team or group in your team's public name. Always make sure your brokerage is the same size or more prominent. Do not imply at any way that the team itself is a licensed brokerage. I chose to speak on this topic because we have been getting a lot of questions in the last couple of weeks about this. So I'm just going to go over actually some of the exact questions we received, and I know now we can answer them very easily. Can a group of licensed agents under a broker form a real estate team? Absolutely, yes. Are there any constraints on a team name? Well, we just learned that there are, and that's going to be in rule. And right now you have to use team or group. Does there have to be a team leader? Absolutely. And that person is designated with the qualifying broker to be that team leader. Are there any constraints on advertising? We just went over that. So now we know, yes, there are. And to whom or which organization does a team have to notify or provide a list of its team members? The only person that they have to provide the list to right now, under the current law, is that they have to provide it to the qualifying broker. And then again, that's going to be part of the audit process if your brokerage is audited. So any questions at all about anything that I've talked about with teams? Okay, I know this was simplistic. I just wanted to go over it because, again, we've been getting a lot of questions on this, and I just want to make sure everyone is clear moving forward how the commission is going to look at teams, the advertising of teams, and the formation of teams. One other topic I just want to briefly touch on. We've had a couple of issues come up with this lately, and I always like when I get some questions, I like to address it. Just make certain that, and I know you all know this, and I don't really know how it's happening, but if there's a wholesale deal going on and the person that is in that deal, there's no commission splitting that can be done between a licensee and a non-licensee, even in that type of environment. So I think there could have been some confusion about that. But anytime a non-licensee is involved in a wholesale transaction, still there can be no commission splitting with that person because if they're not licensed. So I just want to make that very clear. All right, I hope this has been informative, and you can join us for our next Briefly Legal on November 6th. Always remember that you can reach us. Our phone number is 334-242-5544. I want to stop real quick before I give the email. I just want to make sure that everyone understands that in the coming weeks, you're going to be getting a lot of email from the commission because of this new legislation. Please pay attention when new emails come to you, because they're going to be explaining things that we are expecting from the new law and just giving you information on that. So please do not ignore that. Our email is at arec.alabama.gov. Our website is arec.alabama.gov. You can also find us on social media at Facebook, X, Instagram, and YouTube. And our handle for all of that is at AREC Alabama Gov. All right, I hope you'll have an awesome day. See you next time.